Before we begin, please note that the information provided in this presentation is for general informational purposes only and does not constitute legal advice. The content of this video is not intended to be a substitute for professional legal advice from a qualified attorney. Always seek the advice of a licensed lawyer with any questions you may have regarding a legal issue. Reliance on any information provided in this video is solely at your own risk. It starts with a single piece of paper. For Mark, a small restaurant owner in Brooklyn, it was a certified letter with a terrifying law firm letterhead. A former employee was suing him, not for a few $1,000s but for a number that made his stomach drop. Suddenly, the sizzle of the grill and the chatter of happy customers faded into a dull, high-pitched ringing in his ears. His dream, built over a decade of 16-hour days, felt like it was about to shatter. Mark did what most people would do. He panicked. He went online, typed "business lawyer New York," and called the first firm with a slick website and 5-star reviews. They sounded confident, expensive, and exactly what he thought he needed. He paid a massive $5,000 retainer without a second thought. And that was his first mistake. The lawyer was a generalist, a jack of all trades who handled everything from real estate closings to traffic tickets. He didn't understand the nuances of New York labor law. He was slow to respond. The bills piled up, filled with vague descriptions like research and case review, while the lawsuit itself seemed to be going nowhere. Mark felt trapped, bleeding money and losing hope. This story, or a version of it, happens every single day across the 5 boroughs and beyond. Someone gets into a car accident, faces a sudden divorce, gets a notice from their landlord, or like Mark, has their business threatened. You're thrown into a world you don't understand, a world of motions, depositions, and retainers. And the single most important decision you will make, the one that will determine the outcome of your case, your finances, and your peace of mind, is choosing the right lawyer. Making the wrong choice isn't just a small setback. It can be a catastrophic, life-altering mistake. You could lose a case you should have won. You could pay tens of thousands of dollars more than you should have. You could end up with a settlement that barely covers your legal fees, let alone your damages. That's why this guide exists. We are going to pull back the curtain on the entire process of hiring a lawyer in New York. This isn't just a list of tips. This is a complete, step-by-step playbook designed to take you from that initial moment of panic to the feeling of confidence that comes from knowing you have a world-class advocate in your corner. By the time you finish this series, you will know exactly how to identify the specific type of lawyer you need, where to find the elite specialists that don't advertise on billboards, what critical questions to ask during a consultation, how to read and understand a legal fee agreement so you never get surprised by a bill, and how to manage the relationship with your attorney to ensure your case gets the attention it deserves. We are going to demystify the process and give you the tools to level the playing field. And let's be clear. Hiring a lawyer in New York is unlike anywhere else in the country. There are over 180,000 licensed attorneys in New York State. That's more lawyers than the entire population of some U.S. cities. It's a legal ecosystem that is incredibly dense, hyper-specialized, and brutally competitive. The courts are faster, the judges are tougher, and the stakes are higher. Navigating this landscape without a map is a recipe for disaster. A lawyer who is a star in Buffalo might be completely lost in the complex procedural maze of the Manhattan Supreme Court. The strategies that work in a quiet suburban county can backfire spectacularly in the high-pressure environment of the city. You don't just need a good lawyer. You need a good New York lawyer who understands the local rules, both written and unwritten, and knows the players involved. So where do we begin? Before you even think about picking up the phone or typing a name into a search bar, the first and most critical step is to look inward. You need to define your problem with absolute clarity. This sounds simple, but it's where most people go wrong. They call a lawyer in a state of emotional distress and say, "I'm being sued," or "I was in an accident," and they let the lawyer frame the entire situation. You need to be the one in control. Take out a piece of paper or open a new document on your computer and answer 3 simple questions. First, what happened? Write down the story of your situation in plain English, as if you were explaining it to a friend. Don't use legal language. Just state the facts. On May 15th, I was driving down Atlantic Avenue when a delivery truck ran a red light and hit the passenger side of my car. Or, I signed a contract with a web developer to build a site for my business. I paid them the full amount, and they never delivered the final product. Be as detailed as possible. Include dates, names, locations, and any specific numbers. Second, what do you want to happen? This is your ideal outcome. Again, be specific. Don't just write, "I want to win." Do you want financial compensation for medical bills and lost wages? Do you want a contract to be voided? Do you want your ex-partner to agree to a specific custody arrangement? Do you want the charges against you to be dropped? Defining your goal gives you a North Star to guide your entire search. And third, what evidence do you have? Gather every single piece of paper, every email, every text message, every photograph, and every contract related to your situation. Police reports, medical records, invoices, screenshots, letters from the other party. Organize them chronologically. This evidence package is incredibly valuable. When you do eventually speak to a lawyer, you won't be relying on a frantic emotional memory. You'll be presenting a clear, organized case file that immediately shows you are serious, prepared, and a client worth taking on. Once you have this clarity, the next step is to categorize your legal issue. Saying you need a lawyer is like saying you need a doctor. If you have a heart problem, you don't go to a dermatologist. The legal profession is just as specialized, if not more so. Choosing a lawyer who practices the wrong type of law is the single fastest way to lose your case. Let's quickly break down the most common categories. If you've been injured because of someone else's negligence, a car accident, a slip and fall, a case of medical malpractice, you need a personal injury lawyer. Their entire world revolves around proving fault and getting you compensation for your injuries. If you're dealing with a divorce, child custody, or adoption, you're looking for a family law attorney. These cases are emotionally charged and require a lawyer who is not only a skilled negotiator, but also a compassionate advisor. Is someone suing your business? Or do you have a dispute with a partner or vendor? You need a commercial or business litigation lawyer. They live and breathe contracts, corporate structures, and financial disputes. Buying or selling a home or a commercial property. Or maybe you have a dispute with a landlord or tenant. That's the world of real estate law. These attorneys are experts in leases, titles, and property transactions. If you've been accused of a crime, from a DUI to a more serious felony, you need to stop everything and find a criminal defense attorney immediately. Their job is to protect your rights and defend you against the power of the state. There are dozens of other specialties: immigration, bankruptcy, intellectual property, estate planning, but these are the big ones. The key takeaway is this: you must find a specialist. The law is far too complex for one person to master all of it. A general practitioner might be fine for drafting a simple will, but when you're facing a serious legal battle, you need a surgeon, not a GP. You need a lawyer who spends 100% of their time working on cases just like yours. They know the specific laws, the recent court rulings, the opposing lawyers, and the judges who will be hearing your case. That specialized knowledge is your single greatest advantage. Getting this wrong is the difference between success and failure. Now that you've clearly defined your problem and identified the exact type of specialist you need, the real hunt begins. How do you separate the true experts from the thousands of generalists and slick marketers? Where do you find the lawyer that other lawyers turn to when they're in trouble? The answer isn't a flashy website or a billboard in Times Square. It's a process of systematic, intelligent sourcing. Forget everything you think you know about finding a professional in the 21st century. Your first instinct, I guarantee, is to pull out your phone and type "best business lawyer in New York" into a search bar. This is without a doubt the single biggest mistake you can make. Let me be clear. A high Google ranking is a testament to a lawyer's marketing budget, not their legal skill. The top results are either paid advertisements or the product of a sophisticated search engine optimization strategy. These firms have mastered the art of getting your attention. They have not necessarily mastered the art of complex litigation or contract negotiation. You are not looking for the best digital marketer who happens to have a law degree. You are looking for the best lawyer. The two are very, very rarely the same person. Think about it this way. If you needed a life-saving heart operation, would you choose the surgeon with the slickest YouTube ads? Or would you seek out the chief of cardiology at a top hospital, someone whose reputation was built on decades of successful outcomes, not on keywords and ad spend? The legal profession is no different. The truly elite practitioners, the ones who command the highest respect and achieve the best results, are often too busy to manage a flashy online presence. Their clients come from a source far more powerful than any algorithm: trust. So, let's build your search strategy around that one single principle. We're going to create 3 concentric circles of trust, and you will start from the inside and work your way out. The innermost circle, the absolute gold standard, is the direct personal referral. This is not just asking a friend if they know any lawyers. That's too broad. The key is to find someone you trust who has gone through a legal situation as similar to yours as possible. If you're facing a commercial real estate dispute, a referral to a fantastic personal injury lawyer is useless. The skills don't translate. Your mission is to identify anyone in your personal or professional network, friends, family, colleagues, business partners, who has navigated the same treacherous waters you're about to enter. Call them. Ask them not just who they hired but why. What was the experience like? How was the communication? Were there any surprises with billing? And most importantly, what was the outcome and were they satisfied with it? A glowing recommendation from someone who has already paid the price of experience is the most valuable piece of intelligence you can get. It's a pre-vetted candidate. But what if that well is dry? What if your situation is unique and no one you know has been through it? That's when you move to the second circle of trust, your network of other trusted professionals. This is your CPA, your financial advisor, your insurance broker, even your primary care doctor. These are people whose own professional success depends on their judgment and the quality of their network. Your accountant doesn't just see your tax returns. They see the financial fallout of poorly drafted contracts and lost lawsuits. They know which lawyers create clean, defensible work and which ones create messes they have to clean up later. When you approach them, be specific. Don't just say, "I need a lawyer." Say, "I have a shareholder dispute with my business partner involving intellectual property." In your entire career, who is the sharpest, most effective lawyer you've seen handle this specific type of problem in New York? You're not asking for a friend of a friend. You're asking for their professional opinion based on years of observation. Their reputation is on the line with that recommendation, so they will not give it lightly. This is a powerful, often overlooked source of elite legal talent. Only after you have exhausted these first two circles should you even consider moving to the third, outermost circle. This is where we use the internet, but not in the way most people do. We are not going to use Google. We are going to use curated, peer-reviewed professional directories and Bar Association resources. First, the New York State Bar Association and the New York City Bar Association have lawyer referral services. These are not just random lists. They often involve some level of screening. You can call them, describe your situation, and they will provide you with a referral to a lawyer who has listed your specific problem area as a specialty and is in good standing. This is infinitely better than a blind search because it begins with a baseline level of professional vetting. Second, for more complex or high-stakes issues, you can consult professional legal directories like Martindale-Hubbell. This isn't like Yelp. Lawyers can't just buy their way to the top. Martindale-Hubbell has a peer review rating system, with AV preeminent being the highest possible rating. An AV rating is a significant signal. It means that a lawyer's own peers, other lawyers and judges in their community, have ranked them at the highest level of professional excellence and ethical standards. You can't fake that. You can't buy it. You have to earn it over a career. Searching for an AV-rated lawyer in your specific practice area on a site like this is a legitimate way to build a list of potential candidates. Another similar resource is Super Lawyers. Again, this isn't just marketing fluff. The selection process is rigorous, involving a statewide survey of lawyers, independent research, and peer evaluations. Being named a super lawyer or a rising star is a meaningful credential. By using this three-circle approach, you're flipping the script. Instead of letting the best marketers find you, you are actively hunting for the most respected practitioners. You're replacing the chaos of a Google search with a systematic search for excellence. You're moving from a position of vulnerability to a position of power. Your goal from this entire sourcing phase is not to find the one, is to build a short list. A list of 3 to 5 highly qualified, well-regarded attorneys who specialize in your exact problem. You're building a pool of potential champions. Once you have that list of names, vetted through personal referrals, recommended by trusted professionals, or identified through respected peer-reviewed directories, the real work begins. Because a great reputation and a fancy rating are just the starting point. They get a lawyer in the door. But they don't tell you if they are the right lawyer for you. They don't tell you if you'll communicate well, if you trust their strategic vision, or if they have the specific temperament to win your unique battle. You now have a short list of potential champions. But a great name on a piece of paper is just that. Now, you need to find out if they can actually fight for you. The first conversation is where cases are won or lost before they even begin. And it's where you transform from a person with a problem into a savvy, empowered client. So, you're on the phone, or maybe you're sitting across a polished mahogany desk. The air is thick with legal jargon and the weight of your problem. This is the moment. the initial consultation, and your first instinct is probably to just spill everything, to unload the entire messy, complicated story onto this person, hoping they'll just say, "Don't worry, I can fix this." Stop. That's the biggest mistake you can make. You are not here to beg for help. You are here to conduct a job interview. You are the hiring manager. They are the candidate applying for the most important job in your life right now, and you need to run them through the gauntlet. The first thing to understand is the power dynamic. They have the law degree, yes, but you have the case. You have the checkbook. Without you, they're just a person in a nice suit with a lot of student debt. Never forget that. Walk into that meeting or dial that number with the mindset of an employer. You are confident, you are prepared, and you are skeptical. You are looking for the absolute best fit, not just the first person who sounds reassuring. Your primary weapon in this interview is a list of carefully crafted questions. But not just any questions. We're going to break this down into 3 critical areas: the past, the present, and the future. Experience, strategy, and logistics. Get answers to these, and you'll know more about that lawyer than 99% of their clients. Let's start with the past. Their experience. This is more than just looking at their website. It's about drilling down into specifics that matter to you. The first question is always, how many cases exactly like mine have you personally handled in the last 5 years? Don't accept a vague answer like, "Oh, we handle these all the time." No, ask for a number. Is it 5? Is it 50? Are they a general practitioner who dabbles in your kind of case? Or is this their bread and butter? Then you follow up with the killer question. Of those cases, tell me about the one that was most similar to my situation, and what was the outcome? This question does 2 things. First, it forces them to recall a specific instance, proving they actually have the experience they claim. Second, it lets you hear how they talk about their work. Do they speak with clarity and confidence? Do they explain complex legal concepts in a way you can understand? Or do they hide behind jargon and puffery? And since this is New York, you have to get local. Ask, what is your experience in the specific court my case will likely be in? A lawyer who is a legend in Brooklyn might be a complete nobody in a courthouse in Westchester. They need to know the local court rules, the clerks, and most importantly, the judges. Knowing a judge's temperament, their history, and their preferences is a massive, often unspoken advantage. A lawyer who says, "Oh, a court," is a lawyer you walk away from. Now let's move to the present. Their strategy. This is where you find out if they're a fighter, a negotiator, or just a paper pusher. You've given them the basic facts of your case. Now you ask, based on what you've heard so far, what is your initial assessment? What are the biggest strengths and the most dangerous weaknesses of my case? Listen very, very carefully to this answer. A good lawyer will give you a balanced, realistic view. They won't just tell you what you want to hear. They'll be honest about the hurdles. A lawyer who says, "This is a slam dunk, no problem," is either lying or incompetent. The law is never a slam dunk. The lawyer you want is the one who says, "Okay, here's where we're strong. But here, on this point, this is where we're vulnerable, and this is my initial thought on how we can defend it or mitigate it." That's the strategist you're looking for. The next strategy question is, what would be your proposed course of action? What are the first 3 things you would do if I hired you today? This cuts through the fluff. It forces them to lay out a tangible plan. Are they going to file a motion? Start discovery? Contact the opposing party? It shows you if they are proactive and have a clear vision for how to move forward. If they waffle or say, "Well, we'll have to see," that's a red flag. You're not paying for "we'll see." You're paying for a plan. Finally, we get to the future, the logistics, and crucially, the money. This is where so many people get tripped up because they're afraid to talk about cost. Don't be. This is a business transaction. Lead with this. Can you please walk me through your entire fee structure? Leave nothing out. In New York, you'll generally encounter 3 types. First, the hourly rate. This is common in business law, family law, and criminal defense. The lawyer charges you for every minute of their time. You need to ask, what is your hourly rate? What is the rate for paralegals or junior associates who might work on my case? And what is the initial retainer you require? A retainer is like a down payment. They put it in a trust account and bill their hours against it. When it runs low, you have to replenish it. The most important follow-up is, can you give me a realistic, good faith estimate of the total cost from start to finish? They can't give you an exact number, but they should be able to give you a range based on their experience. Second, the contingency fee. This is the standard for personal injury cases. The lawyer only gets paid if you win. Their fee is a percentage of whatever money they recover for you, typically around 33%. The key question here is that percentage calculated before or after case expenses? This is $1 million question, sometimes literally. Expenses are things like court filing fees, expert witness fees, and deposition costs, and they can run into the tens of thousands of dollars. If the lawyer's 33% is taken out after expenses, you keep more money in your pocket. You also need to ask, what happens if we lose? Am I responsible for paying back any of those case expenses? Some firms will cover those expenses if you lose. Others will bill you for them. You absolutely need to know which policy they have. Third, the flat fee. This is common for simpler, more predictable tasks like drafting a will, an uncontested divorce, or handling a basic traffic ticket. It's a single upfront price for the entire job. The main question here is simply, what exactly does this fee cover? And what are the circumstances under which there could be additional charges? Beyond the fees, you need to understand how the firm operates. Ask, if I hire you, will you be the primary lawyer handling my case? Or will it be passed to a junior associate? It's a classic bait and switch. You get wowed by the senior partner in the consultation, but then your case gets handed off to a rookie you've never met. You have a right to know who you will actually be working with. And then the final, crucial logistical question. What is your communication policy? Ask it just like that. How will I receive updates on my case? How often? And if I have a question, what is your standard response time for returning a phone call or an email? A lawyer who can't give you a clear, firm answer on this is telling you everything you need to know about how much they value their clients. Getting left in the dark, waiting days for a simple answer, is one of the most stressful parts of having a legal problem. Solve it before you even hire them. As you ask these questions, you're not just listening to the answers. You're watching them. Are they making eye contact? Do they seem annoyed by your questions? Or do they welcome them? Are they patient? Do they treat you with respect? A lawyer who is dismissive or arrogant in the consultation will be a nightmare to work with when the pressure is on. You are looking for a partner, a guide, not a dictator. You've gathered the intelligence. You've probed their past experience, you've dissected their present strategy, and you've clarified the future logistics. You've transformed a conversation into a deep, diagnostic interview. Now you have a file on each candidate, not just a feeling but cold, hard data. But the decision isn't just about the data. It's about comparing those files, weighing the pros and cons, and making a choice that could alter the course of your life. Because signing that retainer agreement is easy. It's living with the consequences of choosing the wrong advocate that's hard. So how do you avoid that hard road? How do you make sure your choice is the right one? You stop being a potential client and you become a detective. You take that dossier you've built, that gut feeling from the consultation, and you hold it up to the harsh, unforgiving light of public record. This is the vetting stage, and it's the step most people skip. They get a good vibe, they like the office, they're scared and in a hurry, so they sign. And that is a catastrophic mistake. Because a great personality doesn't win a motion to dismiss. A fancy office doesn't cross-examine a hostile witness. You need to know who you are truly getting into business with. Your first stop is the digital precinct, the official record. In New York, this is the New York State Unified Court System's attorney search portal. This isn't a suggestion. It is a non-negotiable step in your investigation. You go to their website, you type in the lawyer's first and last name, and you hit enter. What you're looking for is a simple, beautiful phrase. Currently registered, good standing. That's the baseline. That's the equivalent of a pilot having a valid license. Anything less and you walk away. No explanations, no excuses. If it says suspended, disbarred, or resigned, you close the tab and delete their file from your computer. But good standing is just the beginning. On that same page, you'll see their admission date. How long have they actually been a practicing attorney? The person who told you they had 20 years of experience might have graduated from law school 20 years ago, but only been practicing for the last 5. It's a subtle but critical difference. You'll also see their official business address, which should match what they've given you. Discrepancies are a red flag. Now, for the most important part of the official record, the disciplinary history, this is public information. Think of it like a restaurant's health inspection grade posted in the window. Would you eat at a place with a C rating just because the host was charming? Of course not. So why would you hire a lawyer with a history of misconduct? Disciplinary actions in New York range from a private letter of caution to public censure, suspension, And the ultimate professional death sentence: disbarment. If you see a public disciplinary action, you need to read the court's decision. Don't just take the lawyer's word for it. These documents will detail exactly what happened. Was it a one-time mistake a decade ago involving a technical error in managing a trust account that was quickly rectified? Or was it a pattern of neglecting clients, missing deadlines, and lying to the court? One is a yellow flag that warrants a serious conversation. The other is a blaring 5-alarm fire telling you to run. Pay special attention to complaints about communication. If a lawyer has been disciplined for ignoring clients in the past, they will ignore you in the future. It's a pattern, not an accident. Once you've cleared the official state records, you move into the Wild West. Online reviews. Platforms like Avu, Google, and even Yelp have become battlegrounds for client satisfaction and attorney reputation management. You must navigate this terrain with extreme skepticism. A perfect 5-star rating with dozens of glowing generic reviews is almost as suspicious as a 1-star rating. Look for patterns. If you see 10 reviews that all say John was the best, he really fought for me, and they were all posted in the same week, you're likely looking at a coordinated marketing campaign, not genuine client feedback. What you're searching for is specificity. A helpful review doesn't say, "She was great." It says, "My case was complex, involving a dispute over shared assets in a business partnership. Attorney Smith was able to untangle the financial records. Her paralegal Sarah was always available to answer my calls within a few hours, and she explained the deposition process in a way I could finally understand. We settled for more than I expected." That's a real story. It has details. It mentions other staff members. It speaks to the specific anxieties a client would have. Conversely, read the negative reviews with the same critical eye. Is the client complaining about the outcome of the case? Sometimes bad facts lead to bad results, and it's not the lawyer's fault. A client who lost can easily leave an angry 1-star review. But if the negative reviews all circle the same themes: "He never called me back. I could only ever speak to his assistant. I was billed for things I don't understand. He missed a key deadline," then you are seeing the smoke from a very real fire. The pattern is the truth. One person complaining about communication might be a needy client. 5 people complaining about communication is a negligent lawyer. Next, you'll encounter the world of peer reviews and legal awards. You'll see badges on their website. Super Lawyers, Avu Client's Choice, Martindale-Hubbell AV Preeminent. What do these even mean? Let's break it down. Martindale-Hubbell is one of the oldest and most respected peer review systems. An AV Preeminent rating means that other lawyers and judges have rated that attorney at the highest level of professional excellence and ethical standards. This is a genuinely strong signal. It's not a guarantee, but it's a significant piece of positive evidence. Super Lawyers, on the other hand, is a bit more of a mix. It's a patented selection process involving peer nomination and independent research, but it's also a for-profit enterprise that sells advertising and plaques. Being named a super lawyer is certainly a good thing. Only 5% of attorneys in a state are selected, but don't let it be the only thing that sways you. Think of it as a nice bonus, not the core reason for hiring someone. The Avu rating is a numerical score from 1 to 10. It's an algorithm. It considers information from the state bar, but also things the lawyer self-reports on their profile, publications, speaking engagements, awards. A higher score is generally better, but it can be gamed. A lawyer who spends a lot of time meticulously filling out their online profile might have a higher score than a seasoned veteran who is too busy in court to care about it. Use it as a data point, nothing more. So, as you stand back and look at your completed detective work, the official state record, the online reviews, the peer ratings, a clear picture should emerge. You're no longer just going on a gut feeling. You have a fact-based profile. And now you can run it against the final checklist. The deal-breaker checklist. Here are the red flags that should make you stop, no matter how much you like the person in the consultation. 1. Any active suspension or recent disciplinary history for misconduct involving client funds or dishonesty. This is an absolute, non-negotiable deal-breaker. 2. A clear and consistent pattern of negative online reviews complaining about a lack of communication. This is the #1 complaint clients have, and it's a sign of a chaotic, poorly run practice. 3. Major discrepancies between what they told you and what you found in your research. If they said they've handled 100 trials and you can't find evidence of any, or their office address doesn't match the state bar, something is wrong. 4. High-pressure sales tactics. If they push you to sign the retainer agreement on the spot during the first consultation, they are more interested in your money than your case. A confident, competent attorney will give you space to make your decision. They know their value. 5. A complete lack of an online presence, or conversely, an online presence that feels slick, corporate, and impersonal. In today's world, a good lawyer will have a professional website with real information. If it looks like a stock photo-filled template with no substance, it reflects the quality of their practice. Passing this vetting stage is like getting a green light on a background check. You've confirmed the person is who they say they are. You've verified their credentials. You've cross-referenced their reputation against public and peer opinion. You've done more due diligence than 99% of people who hire a lawyer. You have minimized your risk of hiring a dud, a charlatan, or a nightmare. But the investigation isn't over, because you vetted the person but you haven't vetted the contract. You haven't looked at the one document that will legally bind you to this person, that will define the cost, the scope, and the rules of the entire relationship. And that document, the retainer agreement, is where the most dangerous and costly mistakes are made. It's where a friendly handshake turns into a legally enforceable financial obligation. The devil isn't just in the details, he's in the fine print waiting with a pen. So let's grab that pen and dissect this document before you ever use it. This isn't just a contract. It's the constitution of your legal journey. It sets the rules, defines the powers, and outlines the rights of both you and your attorney. Signing it without understanding it is like agreeing to play a game without knowing the rules, the score, or how to win. The very first section you need to find, the one you should read with a magnifying glass, is the scope of representation. This sounds boring, I know. Sounds like legal jargon. But this clause is the single most important sentence in the entire agreement. It is the GPS for your case. Tells you exactly where you're going and, more importantly, where you are not going. What does it say? Does it say, represent the client in the divorce proceeding? That's vague. That's dangerous. A good scope clause is specific. It will say something like, representation for the purposes of negotiating a marital settlement agreement, and if necessary, filing and litigating a contested divorce action through to the entry of a final judgment in the Supreme Court of New York, County of Kings. See the difference? One is a suggestion, the other is a set of coordinates. Why does this matter so much? Because of a little thing called scope creep. This is the silent killer of legal budgets. Let's say your agreement is for a simple business contract review, but then a dispute arises from that contract. Is handling that dispute included? What about sending a demand letter? What about filing a lawsuit? If your scope clause is vague, the lawyer can and often will say, well, that's a new matter. That requires a new retainer. And just like that, you're back at square one writing another check. A clearly defined scope protects you. It builds a fence around the work you're paying for. Anything outside that fence is a separate conversation and a separate fee. Don't let your simple contract review turn into an all-out litigation war on the same dime, unless that's explicitly what you agreed to. This clause is your shield. Make sure it's solid. Next, we navigate to the heart of the beast. The fee structure. This is the part that makes your palms sweat. It's where the numbers live. In New York, legal fees generally come in three main flavors: hourly, flat fee, and contingency. Understanding which one you have is the difference between a predictable expense and a financial black hole. First, hourly billing. This is the most common arrangement. The lawyer and their staff bill for their time in increments, often as small as 6 minutes, the infamous 1/10 of an hour. You get a bill every month that looks like a phone book, detailing every email, every phone call, every minute spent thinking about your case. The rate can be anywhere from a few hundred to over $1,000 per hour. The danger here is obvious. You have no idea what the final bill will be. A case you thought would take 20 hours could easily balloon to 200. If you're on an hourly plan, your retainer agreement must be crystal clear. Who is billing? Is it just the senior partner at $900 an hour? Or will a paralegal be doing research at $150 an hour? You need to know the rate for every single person who might touch your file. And you must insist on detailed, itemized monthly invoices. Don't accept a bill that just says legal services, $10,000. That's a red flag the size of Manhattan. You have the right to know exactly where every single one of your dollars is going. Second, the flat fee. This is beautiful in its simplicity. The lawyer agrees to do a specific task for a set price. For example, $3,000 for an uncontested divorce, or $500 to draft a will. It's predictable. It's clean. You know exactly what you're paying from day one. This is most common for routine, predictable legal work. But the devil is in the details of that scope of representation clause we just talked about. A flat fee for an uncontested divorce is great, until your spouse suddenly decides to contest it. At that point, the flat fee agreement is usually void, and you're thrown back into the wild west of hourly billing. So if you have a flat fee, make sure you understand precisely what it covers and, more importantly, what events would cause it to end. Third, the contingency fee. This is most common in personal injury cases, though we don't get paid unless you get paid model. The lawyer takes a percentage of your final settlement or award, typically around 1/3, or 33.3%. In New York, there are strict rules governing these fees, especially in medical malpractice cases where the percentages are on a sliding scale. The beauty of a contingency fee is that it gives you access to justice, even if you don't have money up front. The law firm is taking the financial risk, but you need to read the fine print. The key question is that percentage calculated before or after expenses? This is a million-dollar question, sometimes literally. Let's run the numbers. You win a settlement of $300,000. The expenses for the case, expert witnesses, court filing fees, depositions, come to $50,000. If the lawyer's 1/3 is calculated after expenses, they first subtract the $50,000, leaving $250,000. The lawyer's fee is 1/3 of that, which is about $83,000. You walk away with roughly $167,000. But if the contract says the fee is calculated before expenses, the lawyer takes 1/3 of the full $300,000. That's $100,000 right off the top. Then, the $50,000 in expenses is deducted from your remaining $200,000. You walk away with $150,000. That single sentence, before expenses versus after expenses, just cost you $17,000. It's a detail that law firms are banking on you not noticing. This brings us to the next landmine in the agreement, the distinction between fees and costs. They are not the same thing. Fees are what you pay the lawyer for their time and expertise. Costs, also called disbursements or expenses, are the out-of-pocket expenses the lawyer incurs while working on your case. We're talking about court filing fees, expert witness fees, private investigator costs, deposition transcripts, travel, even photocopying and postage. In an hourly or flat fee case, you are responsible for paying these costs in addition to the lawyer's fee. Your retainer agreement must have a section that explicitly details how these costs will be handled. Will they be billed to you as they come up? Or will the law firm front them and add them to your final bill? Who has to approve a major expense? Do you want your lawyer to be able to hire a $10,000 forensic accountant without even asking you first? You need a clause that requires your written consent for any single expense over a certain amount, say $500. This prevents you from getting a surprise bill for $20,000 in expert fees you never knew about. You have to control the checkbook. Never give your lawyer a blank check for expenses. Finally, after you've navigated the scope, the fees, and the costs, you need to find the exit door. This is the termination clause. Think of it as your legal prenup. It governs how the relationship can end, either by you firing the lawyer or the lawyer withdrawing from your case. You, the client, have the absolute right to fire your attorney at any time, for any reason. But it's not always that simple. The agreement will state what happens next. You'll likely be responsible for paying for all the work done up to that point. The agreement should also state that the lawyer must promptly return your file to you. That file is your property, not theirs. It contains all the documents, evidence, and correspondence related to your case. Without it, your new lawyer is starting from scratch. But what if the lawyer wants to quit? The agreement will list the reasons they can withdraw. If you're not paying your bills, if you're asking them to do something unethical, or if the relationship has just broken down. This is a crucial protection for both sides. What you need to watch for are vague terms that give the lawyer an easy out if your case gets too difficult. The clause should be fair and balanced. Scrutinizing this document isn't about being difficult or mistrustful. It's about being a smart consumer. It's about clarity. A good lawyer will welcome your questions. They'll be happy to walk you through each clause and even make reasonable changes. If a lawyer gets defensive or dismissive when you ask to clarify the terms of their own contract, that is not a good sign. That is a red flag telling you to walk away, and walk away quickly. This agreement will govern your life, your finances, and your future for months or even years. You must understand every single word before you sign, because once your signature is on that line, the friendly consultation is over, and the clock starts ticking. And that ticking sound is the sound of money being spent. Now, assuming you've signed a fair agreement with a lawyer you trust, the real work begins. But what does that actually look like? What should you be doing as a client? And what are the first critical steps your new attorney will take? The first thing that happens almost immediately after you sign that retainer agreement is that you get homework. That's right. You just hired an expensive professional to take this burden off your shoulders, and their first move is to give you an assignment. It might feel counterintuitive, but this is arguably the most critical phase of your involvement in the entire case, and your performance here can dramatically shape the outcome. Think of yourself as the lead archivist of your own life. Your lawyer is the master strategist, the general planning the battle, but you are the one who holds the detailed maps of the terrain. They need those maps, and they need them now. Your job is to gather every single shred of evidence related to your case. And when I say everything, I mean everything. We're not filtering for what you think is important. That's your lawyer's job. Your job is to be an indiscriminate, relentless document and data gathering machine. If you're in a personal injury case from a car accident, this means the police report, photos and videos you took at the scene, the other driver's information, any witness contact information, every medical bill, every doctor's report, every prescription receipt, and a detailed calendar of every day you missed from work. If it's a business dispute, you're pulling up every contract, every addendum, every single email chain, text message, Slack conversation, invoice, and payment record related to the deal. For a divorce, it's years of tax returns, bank statements, credit card statements, deeds to property, vehicle titles, retirement account statements, and lists of major assets. You need to create a timeline, a detailed chronological narrative of what happened. Start from the beginning and write down every significant event, conversation, and action with dates. Who said what? When did they say it? Who else was there? This document is pure gold for your attorney. It becomes their Bible for the case. It helps them spot inconsistencies in the other side's story and ensures your own story remains consistent. Don't worry about making it sound legal. Just write it out like you're telling a friend what happened, but with an obsessive focus on detail. The more comprehensive your homework, the faster and more effectively your lawyer can build a powerful case strategy. You are, in these first few weeks, an extension of the legal team. Your diligence up front saves thousands of dollars in legal fees down the road because you're doing the legwork that your lawyer would otherwise have to bill you for or pay an expensive paralegal to do. While you're buried in your own records, your lawyer is kicking off a parallel process that is just as crucial. The moment your file is officially opened, a series of invisible but vital actions begin. First, the administrative machinery grinds to life. The firm runs a final, comprehensive conflicts check to ensure they haven't represented the opposing party in the past. Your case gets a unique file number. A secure digital folder is created, and a physical one is prepared. This might sound like boring clerical work, but it's the bedrock of professional legal practice. More importantly, your lawyer is immediately focused on deadlines. The legal world runs on a terrifyingly strict clock. In New York, the statute of limitations dictates how long you have to file a lawsuit after an event occurs. For a personal injury claim, it might be 3 years. For medical malpractice, it's 2.5. For breach of contract, it's 6 years. Your lawyer's first job is to identify every single relevant deadline and calendar it. Missing a single one of these dates can mean your case is thrown out of court forever, no matter how strong it is. This is Legal Malpractice 101, and it's the first thing a competent attorney secures. Next comes one of the most powerful first moves a lawyer makes: sending a preservation letter, also known as a spoliation letter. This is a formal, legally significant notice sent to the opposing party and anyone else who might have relevant evidence. It essentially says, in very stern legal terms, we are in a legal dispute. You are now under a legal duty to preserve every single piece of evidence related to this matter. Do not delete, destroy, alter, or discard anything. Not a single email, text message, video file, or document. If you do, we will ask the court for severe sanctions against you. This letter freezes everything in place. It prevents the other side from conveniently losing that damning security camera footage or accidentally deleting the email where they admitted fault. It's a legal shot across the bow, and it's one of the most important things that happens in the first 48 hours of your case. Simultaneously, your lawyer begins their own investigation. They'll take that witness list you provided and start making calls. They'll send out formal requests for documents, like an official request to the NYPD or the county clerk for the police report or a property deed. For a personal injury case, they will have you sign HIPAA authorizations, which are medical release forms that allow them to get your complete medical records directly from your doctors and hospitals. This is key because they need to see not just the bills, but the doctor's own notes, the detailed narrative of your injury and recovery. If the case involves a specific location, like a slip and fall at a grocery store or a construction site accident, they may hire an investigator to go to the scene immediately. They'll take photos, measure distances, and look for witnesses or surveillance cameras before the conditions change or memories fade. This initial flurry of activity is about locking down the facts and evidence while they are still fresh. Once you've completed your homework and your lawyer has completed their initial preservation and investigation, you'll have your first true strategy meeting. This is different from the initial consultation. This is where the rubber meets the road. You'll sit down together, spread out all the documents you've gathered, and your lawyer will report on what they've found. They'll merge your detailed timeline and evidence with the documents and information they've independently secured. This is where the story of the case truly takes shape. Your lawyer will start to identify the legal pillars of your claim, the specific laws that were broken, the elements of negligence, or the precise clauses in the contract that were breached. They will also, and this is just as important, identify the weaknesses. Is there a conflicting witness statement? Is there a gap in your medical treatment? Is there an ambiguous phrase in the contract? A good lawyer doesn't just tell you the good news. They stress test the case from the very beginning, thinking about every argument the other side is going to make. Based on this comprehensive review, you'll decide on the opening move. Should we file a lawsuit immediately to put maximum pressure on the other side? Or should we start with a carefully crafted demand letter? A demand letter is a formal letter from your attorney to the opposing party that lays out your legal claims, summarizes the key evidence, and makes a specific demand for a settlement. Often, this is the first time the other party realizes you're serious and have hired a top-tier lawyer. It can be an incredibly effective tool for starting negotiations and potentially resolving the case without ever having to step foot in a courtroom. The decision of which path to take is a strategic one you'll make together, based on the strength of the evidence and the nature of your opponent. Finally, this initial period is when you and your lawyer establish the rules of communication. This is a massive source of anxiety for clients, so it's vital to get it right. Ask them directly. What's the best way to communicate with you? Email or phone? How often can I expect to receive updates? A good lawyer will be upfront about this. They might say, email is best for non-urgent questions, as I can respond between court appearances. We will provide you with a formal update on your case at least once a month, or anytime there's a significant development. If you don't hear from us, it often means we're waiting for the other side to respond, and there's nothing new to report. Understand that you're not their only client. Calling every day for an update will not only annoy them, but will also run up your bill without moving the case forward. Establishing a clear, respectful communication protocol at the start prevents misunderstanding and frustration later. You've hired a professional. Now you have to trust their process. This initial foundation of evidence gathering, investigation, and strategic planning is the launchpad for the entire case. Once this foundation is built and the opening move is made, the case is ready to move into the formal, and often most intense, phase of the legal process. This phase is called discovery, and if the initial filing of the lawsuit is the first shot of a war, discovery is the intelligence gathering operation, the espionage, and the trench warfare that follows. It is, without a doubt, one of the most critical, time-consuming, and strategically complex parts of any New York lawsuit. The entire principle behind discovery is to prevent what lawyers call trial by ambush. The days of a surprise witness bursting through the courtroom doors at the last minute, shouting, "I have the evidence." That's pure Hollywood fiction. The modern legal system, especially in New York, is designed so that both sides have a full and fair opportunity to see all the evidence the other side has before you ever get to a trial. Each party gets to inspect the other's cards. There are no secrets. This process levels the playing field and, more importantly, it allows both sides to accurately assess the true strengths and weaknesses of their case, which is why the vast majority of cases settle long before a trial is ever necessary. So, how does this intelligence gathering operation work? Your lawyer has a specific set of tools, an arsenal of legal mechanisms, to compel the other side to turn over information. The first and most common of these tools are called interrogatories. Think of these as a written, formal 20 questions game, but with deadly serious consequences. Your lawyer will draft a list of specific questions that are sent to the opposing party. They are legally required to answer these questions in writing, and this is the crucial part, under oath. The answers they provide are sworn testimony, just as if they had said them in a courtroom. These questions are designed to lock down the basic facts of the case. Identify every person who was present at the meeting on October 5th. State with specificity every reason you claim our client breached the contract. List every doctor you have seen for treatment of the injuries you allege in this lawsuit. The answers to these interrogatories form a foundational layer of sworn facts that can be used throughout the rest of the case. The next tool in the arsenal is the request for production of documents. This is exactly what it sounds like. Your lawyer formally requests that the other side produce copies of relevant documents, records, and other tangible things. But in the 21st century, the word document is incredibly broad. We're not just talking about paper contracts or printed out letters anymore. We're talking about emails, text messages, server logs, voicemails, photographs, videos, social media posts, financial statements, medical records, internal company memos, virtually any piece of recorded information. This is often where the smoking gun is found. A single email, a forgotten text message, a photograph someone thought was deleted. These things can completely change the trajectory of a case. The process can be monumental. In complex commercial litigation, this can involve reviewing millions of electronic documents, a process called e-discovery, which requires specialized software and teams of attorneys to sift through mountains of data, looking for the few key pieces of evidence that matter. Now we come to the most high-stakes, and often the most intimidating part of discovery, the deposition. A deposition is a formal, out-of-court proceeding where a witness is questioned under oath by the opposing counsel. Imagine this: you're not in a courtroom, but a law firm's conference room. Seated across the table from you is the other side's lawyer. Your own lawyer is next to you, advising and protecting you. And in the corner, a court reporter is silently typing every single word, every stutter, every sigh, into a machine that creates an official verbatim transcript. This is sworn testimony. Lying in a deposition is perjury, the same as lying on the witness stand in a trial. The purpose of a deposition is threefold. First, the opposing lawyer wants to find out what you know. They want to hear your version of the events in your own words. Second, they want to evaluate you as a witness. Are you credible? Are you likable? Do you get angry or flustered under pressure? How will a jury perceive you? They are essentially auditioning you for trial. And third, and most critically, they are locking you into your story. If you testify at a deposition that the light was red, and then months later at trial you try to say the light was green, the opposing lawyer will stand up, pull out your deposition transcript, and read your prior sworn testimony to the judge and jury. Your credibility will be completely destroyed. This is why preparation for a deposition with your lawyer is one of the most important things you will do in your entire case. Your lawyer will spend hours with you, going over the likely questions, practicing your answers, and teaching you the rules of the road. Listen to the question. Only answer the question that was asked. Don't volunteer information. If you don't know, say you don't know. It is a grueling and mentally exhausting process, but it is absolutely essential. The final major tool of discovery is the request for admission. This is a clever device designed to streamline the case. Your lawyer will send a list of factual statements to the other side, and they are required to either admit or deny each one. For example, admit that the signature on the attached contract is your genuine signature. Or, admit that you were the owner of the vehicle involved in the accident on the date in question. If they admit it, that fact is now considered proven for the rest of the case. You don't have to waste time and money bringing in a handwriting expert or a witness from the DMV to prove it at trial. It narrows the issues in dispute, allowing everyone to focus on what really matters. But discovery is not a polite exchange of information. It is a battle. For every request your lawyer makes, the other side's lawyer is looking for a reason to object. They'll argue the request is irrelevant, overly broad, unduly burdensome, or that the information is protected by some form of legal privilege, like the attorney-client privilege. This leads to weeks, sometimes months, of back-and-forth negotiations, letters, and phone calls between the lawyers as they fight over what information must be turned over. This is the trench warfare. Your lawyer is fighting to get the evidence you need, while simultaneously protecting your information from improper intrusion by the other side. And when the lawyers can't agree, that's when they go to the judge. This brings us to a parallel process that runs alongside discovery: motion practice. A motion is simply a formal request to the court to issue an order to do something. If the other side refuses to produce a critical document, your lawyer will file a motion to compel. asking the judge to force them to turn it over. If the other side is trying to get access to your private medical records that have nothing to do with the case, your lawyer will file a motion for a protective order, asking the judge to block their request. This is where your lawyer's skill in written advocacy and oral argument becomes paramount. They will draft complex legal briefs, citing case law and statutes, and then appear in court to argue your position before the judge. The judge's decisions on these discovery motions can shape the entire battlefield of the case, granting access to game-changing evidence or walling it off forever. This entire discovery phase, the interrogatories, the document production, the depositions, and the motion practice that accompanies it, is often the longest and most expensive part of litigation. It can easily last for a year or more in a moderately complex case. It requires immense patience and fortitude from you, the client. You will be asked to dig through old files, answer difficult questions, and have your life examined under a microscope. But this is where cases are won and lost. By the end of this exhaustive process, the fog of war begins to clear. Both sides have a very clear picture of the evidence. They know the strengths, they know the weaknesses, and they can finally make a realistic, informed decision about whether to take a deal or to take their chances at trial. With the facts now fully unearthed, the next strategic phase of the case begins, where lawyers use this information not just to prepare for trial, but to try and win the case without ever stepping foot in front of a jury. This is the phase of litigation that separates the good lawyers from the great ones. It's called motion practice, and it is, without a doubt, a paper and ink war zone. Think of it as a series of strategic, high-stakes legal challenges designed to shape the battlefield before a single juror is ever selected. Each motion is a calculated strike, an attempt to gain a critical advantage, knock out a key piece of the opponent's argument, or even land a knockout blow that ends the entire case. So what is a motion? In the simplest terms, it's a formal request made to the judge for a specific ruling or order, but that definition is far too sterile. In reality, a motion is a meticulously crafted legal argument, sometimes hundreds of pages long, complete with supporting evidence, sworn statements, and citations to dozens of previous court cases. It's your lawyer's chance to speak directly to the judge and say, "Your Honor, based on the law, you need to do this." Early in the case, right after the complaint is filed, you might see a motion to dismiss. This is one of the most powerful early-stage motions. Your lawyer isn't arguing the facts of the case yet. They're making a much more fundamental argument. They are essentially telling the judge, "Your Honor, even if we assume every single allegation in the plaintiff's complaint is 100% true, they still lose." The law simply does not provide a remedy for what they are complaining about. It's like someone suing you for not inviting them to your birthday party. Your lawyer would file a motion to dismiss because, while it might be rude, there's no law against it. The lawsuit has no legal leg to stand on. It fails to state a valid claim. If the judge agrees, the case is thrown out right then and there. Boom! It's over before it even really began. This saves you the immense time, stress, and expense of going through the entire discovery process. It's a clean surgical strike. But the real heavyweight champion of pretrial motions, the one that can decide the fate of the vast majority of civil cases, is the motion for summary judgment. This motion typically comes after discovery is complete, after all the documents have been exchanged, after all the depositions have been taken, after every rock has been unturned. At this point, your lawyer's argument is different. They are now saying to the judge, "Your Honor, we have all the evidence. And looking at all this evidence, there is no genuine dispute about the key facts of this case. The facts are clear. And based on these clear, undisputed facts, the law dictates that my client wins. There is nothing for a jury to decide. We don't need a trial. You can and should grant a judgment in our favor right now." To win this motion, your lawyer has to show that there are no triable issues of fact. A jury's job is to listen to conflicting testimony and decide who is telling the truth, to resolve factual disputes. But if there's no real dispute on the facts that matter, there's no job for a jury to do. Imagine a simple car accident case. The other driver swears he had a green light. You swear you had a green light. That's a classic factual dispute. A jury has to decide who to believe. A motion for summary judgment would fail here. But what if during discovery, your lawyer uncovered a traffic camera video that shows, without any doubt, that the other driver blew through a bright red light? And in his deposition, the other driver admits, "Yes, that's my car in the video." Now, what's the factual dispute? There isn't one. The video evidence is overwhelming. The other driver's claim that he had a green light is now completely contradicted by irrefutable proof. In this scenario, your lawyer would file a motion for summary judgment, attach the video, attach the deposition transcript, and argue that any reasonable jury would have to find in your favor. There's no need to waste the court's time and your money on a full-blown trial. The judge can just apply the law to the undisputed facts and rule that the other driver was negligent. The amount of work that goes into one of these motions is staggering. Your legal team will spend weeks, sometimes months, living and breathing your case file. They will review every single page of every document, every line of every deposition transcript, searching for the key admissions and the smoking gun evidence. They will then spend countless hours in the law library, or more likely on a legal research database, finding every case from the past that supports their position. The final product is a massive, persuasive document that tells the story of your case and methodically dismantles the opponent's arguments, piece by piece, until the only logical conclusion left for the judge is to rule in your favor. Of course, the other side doesn't just sit there. They will file their own massive opposition brief, trying to poke holes in your argument. They'll argue that the facts are in dispute. They'll point to a conflicting statement in a deposition or an ambiguous email and claim that this creates a question that only a jury can answer. It becomes a battle of paper, a war of legal citations and interpretations. The judge will then read everything, all of it. The motion, the opposition, the reply briefs, all the attached evidence. And often, the judge will schedule something called oral argument. This is where the lawyers appear in court, without a jury, just the judge on the bench, and verbally argue the motion. The judge will pepper them with tough questions, testing the weak points in their arguments. It's an intense intellectual showdown. And then you wait. It could be weeks or more often months before the judge issues a written decision. This period of waiting is one of the most nerve-wracking parts of the entire litigation process for a client. The entire fate of your case hangs in the balance, resting on a single decision. If your lawyer wins the motion for summary judgment, it's a monumental victory. The case is over. You've won. If you were the defendant, the claims against you are dismissed. If you were the plaintiff, judgment is entered in your favor, and the only issue left is to determine the amount of damages. If you lose the motion, it's not the end of the world, but it is a significant moment. It means the judge believes there are enough factual disputes that a jury needs to hear the case. It means you are, with near certainty, heading to trial. The outcome of these motions has a colossal impact on settlement negotiations. If you file a powerful motion for summary judgment, the other side might suddenly become much more reasonable and offer a favorable settlement to avoid the risk of losing everything. Conversely, if your motion is denied, your leverage might decrease because now the other side knows they'll get their day in front of a jury. Beyond these two major motions, there are countless others that shape the case. There are motions in limine, which are filed right before trial to ask the judge to exclude certain evidence. For example, Your Honor, we ask that the plaintiff be prohibited from mentioning my client's prior business dispute from 10 years ago. It's completely irrelevant to this contract case and would only serve to prejudice the jury against him. Winning these motions can be critical, as it prevents the other side from using inflammatory or irrelevant information to poison the jury pool. There are also motions to compel, which we touched on before, to force the other side to hand over discovery they've been withholding. There are motions for sanctions, asking the judge to punish the other party for bad behavior, like destroying evidence. Each motion is a tool, a weapon in your lawyer's arsenal, used to control the flow of information and frame the case in the most favorable light possible. This entire phase is a complex, strategic chess match, played for the highest of stakes. It's where legal expertise, persuasive writing, and strategic thinking converge to try and secure a victory long before anyone ever says, "All rise." But what happens when the motions don't end the case? When both sides have thrown their best legal punches and the case is still standing? That's when the focus shifts from legal arguments on paper to preparing for the ultimate showdown, the trial. And that preparation is an entirely different beast, a meticulous process of marshaling your evidence, preparing your witnesses, and crafting the narrative that you will present to the jury. This narrative isn't just a dry recitation of facts. It's the story of what happened told from your perspective, designed to be clear, compelling, and most importantly, persuasive. It has a beginning, a middle, and an end. It has a hero you, and it has a conflict that needs resolution. Your lawyer's job is to transform a mountain of legal documents, emails, and depositions into a story a jury can understand, connect with, and ultimately believe. This is where legal skill transcends into the art of storytelling. This process of story building happens in what lawyers call the war room. It's a period of intense, focused preparation that can last for weeks or even months leading up to trial. Your legal team will live and breathe your case. Every piece of evidence is scrutinized not just for what it says, but for how it fits into the larger puzzle. That single email from 2 years ago? It's not just an email anymore. It's Exhibit 74A, a crucial piece of the timeline that proves intent. That blurry photograph? It's Exhibit 112C, corroborating a key witness's testimony about where they were standing. They will create what's known as a trial binder, or more likely these days, a digital equivalent. This is the case's Bible. Every document, every deposition transcript, every photograph, every expert report is meticulously organized, tabbed, and cross-referenced. Your lawyer needs to be able to pull up any piece of evidence in seconds, at the exact moment it will have the most impact on the jury. They'll also be preparing demonstrative aids, the visuals that make complex ideas simple. Think charts showing financial damages, timelines of events, or even 3D animations recreating an accident. Jurors remember what they see far better than what they only hear. And a powerful visual can be the difference between a juror understanding your point and being completely lost. But the most human, and often most unpredictable, element of any trial is the witnesses. And preparing them is one of a lawyer's most critical tasks. This is not, as television might suggest, about telling a witness what to say. That is illegal and unethical. It's about teaching a truthful witness how to effectively communicate that truth under immense pressure. Your lawyer will spend hours with you and your key witnesses. They will go over your testimony again and again, not to memorize a script, but to ensure you are comfortable, confident, and precise with your answers. The most important part of this is the mock cross-examination. Your lawyer will transform. They will stop being your advocate and become your worst enemy. They will adopt the persona of the opposing counsel and hit you with every tough, tricky, and misleading question they can imagine. So, you're saying you don't remember what you had for breakfast that day, but you have a perfect memory of this one conversation? Isn't that a bit convenient? You were in financial trouble at the time, weren't you? Desperate, even. The goal is to prepare you for the fire, to teach you not to get angry, not to get flustered, to learn how to answer only the question that was asked, to say, "I don't know" when you don't know, and to remain calm and credible even when you're being attacked. A witness who is prepared can withstand a brutal cross-examination. A witness who isn't can have their credibility destroyed in minutes, taking the entire case down with them. With the evidence organized and the witnesses prepared, the next battle is for the hearts and minds of the jury. This begins with a process called voir dire, a French term meaning to speak the truth. This is jury selection, and it is a high-stakes psychological game. In a New York courtroom, a pool of potential jurors is brought in, and the lawyers for both sides get to ask them questions. The stated goal is to find a fair and impartial jury. The real goal for your lawyer is to identify and remove the people who are most likely to be biased against you in your case, for whatever reason. Your lawyer will ask questions designed to uncover hidden beliefs and life experiences. They aren't just listening to the answers, they're watching body language, listening to tone, looking for any sign of a closed mind. They might ask things like, "Does anyone here believe that if someone files a lawsuit, they're probably just looking for a quick payday? Or has anyone had a particularly negative experience with a landlord that might affect how you view this contract dispute?" Based on the answers, lawyers can ask the judge to dismiss a juror for cause if they show clear bias. But each side also gets a limited number of peremptory challenges, which are basically get-out-of-jury-free cards. They can strike a potential juror for almost any reason at all, or no reason. Maybe the lawyer just got a bad feeling. Maybe the juror's profession makes them unsympathetic. This is where a lawyer's intuition and experience in reading people become invaluable. Selecting a jury isn't a science, it's an art. And the 12 people who are ultimately chosen will hold the fate of your case in their hands. Once the jury is impaneled, the trial officially begins. And the first thing they will hear is the opening statement. This is, without a doubt, one of the most important moments of the entire trial. It is your lawyer's one and only chance to tell your story, from beginning to end, without interruption. It is the movie trailer for your case. It needs to be powerful, persuasive, and memorable. Studies have shown that a huge percentage of jurors make up their minds after the opening statements and spend the rest of the trial looking for evidence that confirms their initial impression. A great opening statement isn't a boring list of what witnesses will say. It's a narrative. Sets the theme. This is a case about a promise that was broken. Or, this is a story about a company that chose profits over safety. It introduces the key players, establishes the stakes, and provides a roadmap for the jury, telling them what evidence they are about to see and how it all fits together. Your lawyer is making a promise to the jury. I will show you this, this, and this. And for the rest of the trial, they must deliver on that promise. A weak, confusing, or boring opening statement can put you in a hole you may never climb out of. A powerful opening statement frames the entire trial and gives the jury the lens through which they will view every single piece of evidence. But even before the first word of that opening statement is spoken, a final crucial phase of preparation is happening behind the scenes. Your lawyer is not just preparing your case. They are actively working to dismantle your opponents. This involves anticipating their every move, their every argument, and preparing counterattacks. It also involves a powerful legal tool. Pretrial motions, specifically motions in limine, which is Latin for at the start. These are requests made to the judge, outside the presence of the jury, to rule that certain evidence cannot be presented during the trial. For example, imagine your opponent wants to bring up a completely unrelated business dealing you had 5 years ago that went sour just to make you look bad. Your lawyer will file a motion in limine arguing that this information is irrelevant to the current case and is being introduced solely to prejudice the jury against you. If the judge agrees, your opponent is forbidden from even mentioning it. Winning these motions can be a massive victory. You can cripple the other side's case by getting their star witness's testimony excluded on a technicality, or by preventing them from using a smoking gun document that was obtained improperly. This is the strategic chess match that happens before the trial even begins, shaping the battlefield and defining what the jury will, and just as importantly, will not be allowed to hear. With the jury selected, the exhibits prepared, the witnesses drilled, and the opening statements rehearsed down to the last syllable, the curtain is about to rise on the main event. The trial begins not with a bang but with a story. 2 stories, actually. This is the moment of the opening statements. Your lawyer stands before the jury, not as an arguer, but as a narrator. They will lay out a roadmap of the case, a promise of what the evidence will show. This isn't the time for fiery rhetoric or legal jargon. It's a time for connection. Your attorney will introduce the key players, outline the sequence of events, and present the theme of your case in a simple, compelling narrative. They are planting the seeds of their argument, creating a framework that the jury can use to organize the mountain of information they are about to receive. The opposing counsel will then do the exact same thing, presenting their own version of events, their own narrative. From this moment on, the jury will be filtering every piece of testimony, every document, through one of these 2 competing stories. Following the opening statements, the plaintiff, the party who brought the lawsuit, presents their case in chief. This is their opportunity to build their argument brick by brick, in front of the jury. They get to go first because they have the burden of proof. They are the ones making the accusation, so the law requires them to be the ones to present evidence supporting it. This phase is a carefully choreographed presentation of witnesses and exhibits. Your lawyer will call their first witness to the stand. This could be you, an eyewitness, a police officer, or an expert in a particular field like a doctor or an accident reconstructionist. The process of questioning a witness you have called is called direct examination. The goal here is to have the witness tell their story to the jury in a clear and credible way. The rules of evidence are strict. Your lawyer can't ask leading questions, which are questions that suggest the answer. For example, they can't ask, "You saw the red car run the stop sign, didn't you?" Instead, they must ask a series of open-ended questions. Where were you standing? What did you see? Describe the intersection. What color was the car? What did you observe the car do? It's a delicate art, guiding a witness through their testimony without putting words in their mouth, allowing the story to unfold naturally for the jury. Each piece of evidence, whether it's a medical record, a damaged part from a vehicle, or a threatening email, must be introduced through a witness who can authenticate it and explain its relevance. This is a methodical, often slow process, but it's the bedrock upon which the entire case is built. After your lawyer finishes questioning their witness, the opposing counsel gets their turn. This is cross-examination, and it is the part of the trial that makes for the best television drama, because it is pure strategic combat. The goal of cross-examination is the exact opposite of direct examination. The opposing lawyer is not there to let the witness tell a story. They are there to dismantle it. They want to limit the witness's answers, control the narrative, and expose any weaknesses, inconsistencies, or biases in their testimony. They will use leading questions almost exclusively. You were 100 feet away, correct? It was dark, wasn't it? You've had a long-standing feud with my client, yes or no? A skilled trial attorney on cross-examination is like a surgeon with a scalpel. They will probe for inconsistencies between the witness's testimony and their earlier deposition. They will challenge their memory, their perception, even their character. They are trying to do one of two things: either get the witness to admit a fact that is helpful to their side, or destroy the witness's credibility in the eyes of the jury, making them seem unreliable, biased, or untruthful. Your lawyer's job during this phase is to be vigilant, ready to object if the opposing counsel crosses a line, asking improper questions, mischaracterizing testimony, or harassing the witness. It's a high-stakes, high-tension chess match, and a single misstep by a witness can have devastating consequences. Once the plaintiff has called all of their witnesses and presented all of their evidence, they rest their case. Now the tables turn. The defense gets to present its case in chief. They will call their own witnesses and introduce their own exhibits to rebut the plaintiff's claims and to build their own narrative. The process is identical, just in reverse. The defense lawyer will conduct direct examination of their witnesses, and your lawyer will have the opportunity to cross-examine each one, seeking to poke holes in their story and undermine their credibility. The defense may try to establish an alibi, present an alternative theory of what happened, or attack the character of the plaintiff. Your attorney must be just as prepared and aggressive in cross-examining their witnesses as they were in defending yours. After the defense rests, the plaintiff may have a chance for a rebuttal. This isn't a chance to rehash the whole case, but a limited opportunity to present new evidence or witnesses specifically to contradict new points the defense brought up during their case. Once all the evidence has been presented and all the witnesses have testified, the stage is set for the grand finale, the closing arguments. This is where the lawyers finally get to argue. They step away from the witness stand and the evidence table and speak directly to the jury. This is their last chance to persuade. A great closing argument is a masterpiece of storytelling and logic. Your lawyer will weave together all the disparate threads of testimony and exhibits into one cohesive, powerful narrative. They will circle back to the promises they made in their opening statement, showing the jury step by step how the evidence they presented fulfilled those promises. They will highlight the strengths of their case and, just as importantly, the glaring weaknesses and inconsistencies of the opposition's case. They will appeal not just to the jury's logic, but to their sense of justice, their common sense, and their emotions. It is a performance, a passionate plea, and the final lasting impression your case will make. When the echoes of the closing arguments fade, the judge takes center stage. They will read a long and often complex set of jury instructions. These instructions are the law. The judge explains the relevant legal principles, defines the claims the jury must decide on, and outlines the burden of proof. The jury is then handed a verdict form, they take an oath, and a court officer leads them from the courtroom to the jury room. The door closes, and then there is silence. This period of jury deliberation is one of the most agonizing for any client. Your fate, your future, is now in the hands of a group of strangers behind a closed door. Deliberations can last for hours, days, or in complex cases, even weeks. There is no way to know what is being said, what evidence is being debated, or which way the tide is turning. All you and your lawyer can do is wait. The wait ends with a single phone call or a knock on the door. The jury has reached a verdict. Everyone reassembles in the courtroom. The atmosphere is thick with a tension so profound you can almost taste it. The jury files back into the jury box, their faces unreadable. The judge asks the foreperson if they have reached a verdict. They say yes and hand the verdict sheet to the court officer, who gives it to the judge. The judge reviews it and hands it back to be read aloud. In that moment, time seems to stop. The foreperson stands and, in a few short sentences, reads the jury's decision. Guilty or not guilty, liable or not liable. The culmination of months or even years of fear, stress, and relentless work is delivered in a single irreversible moment. But even then, the story may not be over. If the verdict is against you, your lawyer will immediately begin analyzing the trial for grounds for an appeal, arguing that a legal error was made by the judge that impacted the outcome. If you win, the other side may do the same. There can be post-trial motions to set aside the verdict or to reduce a damages award. The legal system has layers of checks and balances, and the finality of a trial verdict is often just the beginning of a new chapter in the appellate courts. From that first frantic moment you realized you needed help, to the final word read from a verdict sheet, the legal process is a labyrinth. It is a journey through a foreign land with its own language, its own rules, and its own unforgiving terrain. Navigating it alone is nearly impossible, but having the right guide, a skilled, dedicated, and tenacious lawyer, transforms the journey. They are your translator, your strategist, your shield, and your champion. They are the ones who can take a chaotic mess of facts and fears and forge them into a compelling story of truth, fighting to ensure that your story is the one that is heard, understood, and ultimately believed. The process is daunting, but with the right advocate by your side, it is a process you can not only survive but overcome.